Welcome to Crash Course, a podcast about business, political, and social disruption, and what we can learn from it. I'm Tim O'Brien. Today's Crash Course, Trump versus his first big fraud verdict. Donald Trump's civil fraud trial in New York is drawing to a close. Testimony recently ended. And sometime in early 2024, a state judge will rule on the case. It's within the judge's power to impose a fine of as much as $250 million on Trump and permanently ban him and his company from ever doing business in New York again. The state where Trump grew rich may send him into financial exile. State prosecutors allege that Trump arbitrarily inflated the value of his assets to secure bank loans and deceive insurers while deflating the value of those same assets whenever he wanted to lower his tax bill. Trump, his two eldest sons, and their lawyers all say they never misled anyone, and nobody suffered any financial damages, they say. No harm, no foul. The New York case is one of several lodged against the former president. He also faces criminal fraud charges in New York, state election fraud charges in Georgia, and two federal cases involving the January 6th insurrection at the U.S. Capitol and the misappropriation of classified documents. All of this is landing while Trump appears to be well on his way to securing the Republican nomination for the presidency next year. It's serious, it's a mess, and the rule of law is being severely tested. So I am jazzed to discuss all of this with Andrew Weissmann. Andrew, a professor at NYU Law School, spent many years as a federal prosecutor and investigator. He tackled organized crime cases with the U.S. Attorney's Office and fraud cases at the Department of Justice. President George W. Bush appointed him as the FBI's lead investigator in the infamous Enron case. Special counsel Robert Mueller recruited him to be the lead prosecutor in his probe of Team Trump's intersection with Russia before and during the 2016 presidential election. And Andrew, the author of Where Law Ends, knows a lot. Welcome to Crash Course, Andrew.
So great to be here.
You know, you had this reputation as a pit bull prosecutor. That's what they said during the Enron prosecution. And I'm sure the Trump team were freaked out when Robert Mueller recruited you to join in his effort. And I've always found you to be an absolute sweetie. You know, easy to talk with, articulate, judicious. I would never call you a pit bull, but I actually haven't ever been prosecuted by you either.
So you haven't had that pleasure yet.
I haven't had that pleasure yet. Would you describe yourself as a pit bull?
A friend of mine on the Mueller special counsel team said, you know, the secret is you're really squishy. So I think some of that is probably deserved. When I started out as a young prosecutor and I was doing organized crime work here in New York, I think like a lot of young prosecutors, I was probably a bit over the top and imperious. So I think that may have helped. But I think it then just becomes, in some ways, it's kind of a useful thing for defendants to fear you because, you know, you're trying to get people to cooperate. And if they think that you're really tenacious and you're going to find everything out, that's not a bad thing for defendants and their counsel to think. I do think it's a bit undeserved, but you know what? It is what it is. And people make their own judgments, you know, as to what they'd like to think.
I mean, that's very much the way I think about it. When I think about you, you know, we're not friends, we're acquaintances. We've done some TV together. We recently chatted over a couple glasses of wine at a party in Manhattan. But interacting with you in these situations and then watching your professional life, I do see these sort of dualities. You're a very normal, judicious man, personally, and you take your role very seriously. And you were prosecuting people like John Gotti, I would mention. And the Enron folks weren't Boy Scouts, as we all know. But in a broader way, tell me how you think about the role of prosecutors in our society. Like, what is their fundamental role in terms of ensuring that the rule of law is a viable and stable thing?
Well, I think that prosecutors have enormous amount of power, and they also have a lot of discretion with respect to who gets charged and who doesn't. So there's an ineffable quality that I think you look for when you're hiring people to be a prosecutor, which is maturity and judgment. But exactly what that means in any particular case can vary, and it's also hard to articulate that. But I think it's really important to understand how weighty that power is and the dual function of a prosecutor, which is to do justice And that means it doesn't mean just winning the case. It is adherence to the rule of law, even if it's not going to help you win. I won't say there's nothing worse, but it is incredibly upsetting to people who've been in the department when you see prosecutors who are not scrupulously adhering to that dual role of what it means to be a prosecutor.
So let's spend a minute and talk about the Mueller probe and the attendant Mueller report, which you wrote about in your book, How Law Ends. I read your book and I found it to be poignant in a way in that you were surrounded by great people. Robert Mueller, an admirable and legendary prosecutor and investigator himself, taking on a seminal political and national security issue involving Donald Trump's intersection with Russians, whether they helped him in the election or did other things to thwart Hillary Clinton. And you got a lot of results out of that. Paul Manafort and Michael Flynn were indicted. 34 individuals and 3 companies were charged. You got 8 guilty pleas. At the end of the day, Mueller decided not to charge Donald Trump with obstruction of justice, which is one thing I wanted to talk with you a little bit about. He also chose not to follow the money trail, which always perplexed me. And then, William Barr, Donald Trump's attorney general, in a 4-page statement, got to redefine a 448-page report in the popular imagination. I think you refer to the report in your book as mealy-mouthed, if I'm quoting you correctly, and that Mueller might have been overly confident himself in Barr's own respect for the rule of law or how he was operating as a political player. So that's a lot of preamble from me to kind of ask you about how you think about that experience in the Mueller probe.
Well, that was a lot of different aspects. So let me just go back over a couple things and then I'll go back to the big picture of your question. I think that I did in my book describe certain conclusions in the book as mealy-mouthed, particularly the conclusions of volume 2 of the Mueller report was about the obstruction. And, it had famously the line about, if we could conclude that he did it, we would not say this. It would have like 3 double negatives, and it was just very hard to follow. And I always thought, who are we kidding? Volume 1 said essentially that the proof didn't rise to the level of being able to say that there was actual coordination as opposed to a lot of people on both sides who wanted to coordinate, and there was active assistance from Russia, but we didn't see enough evidence of actual coordination.
To prove a criminal conspiracy. There was certainly cooperation, but not enough evidence to say it was a criminal conspiracy.
I was like, so if we're doing that in volume 1, who's going to really be fooled in volume 2 where we're not saying that? It's like so obvious that we're saying there is. It turns out I was wrong. It's like that kind of double negatives had people going, gee, what are they saying? So I thought that was mealy-mouthed. I thought we should have just said it. The other thing that's really important to note is we could not charge the then president of the United States with a crime because the DOJ policy was that a sitting president could not be charged by the Department of Justice. There were 2 Office of Legal Counsel opinions on that. And even though we're in the special counsel's office, the special counsel is part of the Department of Justice. We had to adhere to Department of Justice rules. So we did not have that authority. So, one of the things that I talked about in my book is that I thought it would have been really great if, like Rod Rosenstein, when he appointed us, had made it clear to people what our purview was and what we could and could not do. We were all very aware that people in the public were thinking, oh, any day now there could be an indictment of the sitting president. And we were like, that's not even remotely on the table. We cannot do that. We would have rightly been fired. I'm not saying that the policy is necessarily a good one. I'm not even sure that the law requires that a sitting president cannot be charged. I have a whole theory as to why I actually think a sitting president could be charged by the federal government. I think the states raise a very separate issue, but we didn't have that luxury because we just couldn't make up DOJ policy. We had to adhere to it or be fired.
Also, remember, it was in the context of Trump having fired Jim Comey as the head of the FBI after he was probing some of these issues himself.
Yeah, well, that and, it was just a very hard investigation to do. I remember feeling very much the same feeling I had when I worked on the Enron task force. which is you feel an enormous amount of pressure that's coming from within you to be thorough, not make any mistakes, and to work as hard and as fast as you can, because the time clock that you feel, the pressure of that is that you feel like the public deserves an answer, the political system deserves an answer as fast as humanly possible. So that was a very intense 22 months.
And a lot of the dynamics you encountered during that probe are the ones that still exist around all of the current Trump prosecutions. He's an unusual person to prosecute or investigate because he inveighs willy-nilly against law enforcement officials, judges. He's threatening. Often he calls up his troops, the Trump supporters across the country, to get on his side in these matters. So you've lived already through what other prosecutors and investigators are dealing with right now. I want to come back to one thing on the Russia part of the probe. It was always curious to me that money as a reason for Trump's intersection with Russians beyond just his own interest in a political victory or defeating Hillary Clinton. But he obviously, came into the 2016 race with a long history of voracious deal making. And if you put a bag of cash on Donald Trump's desk, he would bark and bark and bark again. It seemed to me like a good and useful evidentiary path for Mueller's team to go down.
There are many things that I totally agreed with what my boss, Director Mueller, was doing and the calls he made. And obviously it's his decision. It wasn't mine or anyone else reporting to him. But there's some where I disagreed. This is one where I understood initially why we did not investigate the financial aspect of the case initially, but disagreed why we didn't come back to it. And the reason I say that, and I wrote about this in the book, which is, if you remember early on, we were just sort of up and running in June of 2017. Donald Trump had said that sort of essentially his relationship with Deutsche Bank, the financial stuff, was sort of off limits and a red line. And when we were just starting out, I could see saying, look, well, there's so much else to do. Let's get a toehold. Let's get our feet wet and see where these cases are going, and then be able to figure out how the financial piece could play into any particular part of the investigation. I was doing sort of Manafort and all things Manafort related. And so my remit did allow for a financial investigation with respect to them. Remember, we had to follow Rod Rosenstein's parameters with respect to what we could look at. It was not like being in the U.S. Attorney's Office where it's like any federal crime. So I had that luxury, but my colleague Jeannie Rhee, who headed up Team R, which was Team Russia, I was Team M, which is, we were not very creative. M was Manafort. So she didn't have that sort of broad remit. And I think what the thought was in the beginning, like, why cross a line that we didn't necessarily need to cross at that point? We didn't even understand at the moment. We now learned that Don McGahn had been approached by the president to fire us. And, that was just a few weeks into the investigation. So I think that that is a more justifiable time period to have said there's no reason to do it now. My issue is I thought that, for instance, as Michael Cohen came in and talked about the Moscow project, that gave some more impetus for doing a financial investigation.
And just for our listeners' sake, the Moscow project was a real estate project in Moscow to build a Trump Tower in Moscow that Trump was actively trying to make real both during the campaign and in the run-up to the campaign. It wasn't a past issue. And it obviously, you don't build anything in Moscow unless Vladimir Putin wants to let you build something in Moscow. And that always seemed to me like a very clear evidence of a presidential candidate who could get played by a foreign power.
Yeah. And remember, people think of the Michael Cohen case as one that was solely prosecuted by the Southern District of New York. And in fact, that isn't the case. We were looking at Michael Cohen, saw the Moscow piece of it. We retained that because it was within our remit. But when we saw that there were personal crimes and sort of other crimes unrelated to our remit, those we spun out to the Southern District of New York. And obviously there was coordination of that. And he ultimately pleaded guilty to both sets of charges. So that's why you sort of have those different pieces. And that's a very good way of understanding that we had limited jurisdiction because we had to stay within what Rod Rosenstein said was something we were allowed to investigate. If we had just been in a U.S. attorney's office, we would have done everything.
So in other words, none of this was arbitrary. The reason the money trail wasn't pursued was because the remit had reasonable and narrow boundaries.
That's true, but I do want to say, I do think that as our case progressed, there were grounds that we could have used to do more. And so that is an area where I do think that we could have revisited it and could have made the arguments about doing more on the financial front as our case got deeper and we had more factual predication for that type of investigation. So I don't think I can blame the limited remit entirely for why we didn't do the financial piece as broadly as you would if you were in the U.S. Attorney's Office.
Since we've talked about the money trail, this brings us to Letitia James's case, which is all about the money. I want to, before we get into that, take a quick break so we can hear from one of our sponsors. And then when we get back, I want to dive into that case with you. I'm back with Andrew Weissmann, and we're discussing the New York Attorney General's prosecution of Donald Trump. So Letitia James, the New York State Attorney General, begins investigating Donald Trump in 2019 for financial fraud, as I noted in the top of the show. And in 2022, she sues him, his company, his 3 eldest children, and 2 officers of the company, his CFO and his chief operating officer, for financial fraud. Their defense really is, Trump always exaggerates, no one was harmed, fake issue, this is a political prosecution. That's essentially what their defense is boiled down to.
I'm going to complicate that, and you can tell me what I'm missing. So I think that the parts of the case that seem very strong from the outside, I think that the information about Trump Tower and his apartment and the fact that it was valued at 3 times the square footage seems like a rock crusher. I don't know how you get around that. And it's not just that, because somebody who would do that, you have to ask, well, if they're going to do that and it's so blatant, do you really think that's the only time that they're willing to do it? And if you don't have the moral fiber to be saying, that's not what I'm going to engage in, why would you just draw the line there when the other things are sort of harder to catch? I also think the valuation at Mar-a-Lago seems pretty, not quite as, but pretty open and shut. And that is that he valued it taking away all sorts of restrictions that he had agreed to on that property. And a similar thing happened in other real estate.
Seven Springs, the estate up in...
Exactly, where he would, for instance, say, well, I'm assuming that this was not rent regulated. And, I live in New York City. The idea that I'm going to value something as if there weren't rent-controlled apartments in the building, just to give an example, I mean, it's obviously there's a really big difference in terms of valuation if you have tenants who are rent-controlled versus free market. So I know that Trump's team put on a defense expert to say that that's legit to do that. That just seemed really strained to me as accurate.
Well, but I think, I'm sorry to jump in here, but I think the thing that we got to get clear about is what was he doing with these valuations? So, we can all say it's bonkers that Donald Trump valued this triplex at the top of Trump Tower that looks like it was designed by like Louis XIV on a drug trip, and put on his own papers and what he was saying to the press and everyone that, yes, this is 3 times what it really should be. And my jet is worth 10 times and it has golden toilets. And, I've got these towers everywhere and they're 10x what everyone else's building is worth. But if he's actually not using that exaggeration to either secure loans he shouldn't get and banks are duped in the process, or, the converse, which I know at the top of the show, is that he overly deflated the values of some of those same assets when it lowers his tax bill, that there's actually a consequence of his inflation or deflation, that the act of inflating is just, so what? Donald Trump has spent 60 of his 77 years doing this kind of stuff.
Oh, yeah. There's a motive for all of that. The motive is money. I mean, the motive is either, as you said, to pay less in taxes or to get greater loans.
But isn't that the thing, though, Andrew? Isn't that where the bar here is for the prosecutors, is to show it isn't the simple act of him treating valuations like a yo-yo. It's that he used the yo-yo to hurt someone and to defraud someone.
Yes, but that's sort of a legal piece, which is, so there's already been one cause of action, which the judge found before the trial started, found liability. And that's because that first cause of action doesn't require mens rea, doesn't require intent to defraud, nor did it require materiality or reliance. So it's a very broad cause of action under the law. I mean, that is New York law. I think the judge got that right. The other causes of action that were on trial do require materiality and intent. And so a lot of the things that we've been talking about could go to Donald Trump's intent, that he wasn't intending to defraud because there was an expert who said you could do this, etc. And also remember, the standard here is not proof beyond a reasonable doubt. It's just a preponderance, which is 50% and a hair. Anything over 50%, the state has established its case. And this is where I think that there are parts of the case where I think they seem stronger than others. And I'm curious as to what you thought, Tim, because they did have people from Deutsche Bank, one of the main lenders, saying essentially, hey, we did our own work. We wanted to do work with him. We did our own valuations. So essentially, like, we weren't really relying on what he wrote down. Now, reliance is not actually an element of the causes of action, meaning that the state doesn't have to prove that Deutsche Bank relied. They just have to show that there was an intent to deceive Deutsche Bank and that the kind of information that was being put forward would be material. In other words, it's not like, what's your favorite color? It's something that would be relevant. And I think all of this is the kind of thing that would be relevant. And my argument would be, if this isn't material, then why even have the application? If it really doesn't matter what you write down and you can make up the numbers, why even have the application? And I think if you were to ask the general counsel of Deutsche Bank, they would have to say, well, of course we want truthful information and we do care what people write down. It would be pretty unusual for a bank, for the general counsel, the chief compliance officer, to say, we don't really care whether we're giving to customers who are just defrauding people all the time. That obviously has to be material. I just don't know how good a job the state did in the cross-examination and the rebutting of that defense testimony.
Well, I think they did a really weak job. And I think they could have come. I mean, there's so many elements of this case, to bring our listeners back in on some of the directives around it. New York state prosecutors have a lot of freedom to go after financial fraud in an unusual way. There's the Martin Act, which essentially allows prosecutors to pursue financial crimes without even they don't have to prove intent, as they don't need to in any civil case, but the Martin Act redefines that boundary as well. And they don't even have to show that someone was damaged necessarily. They just have to show that someone tried to pull off a fraud.
Right.
And those are the tools that Letitia James has brought to bear on Trump. Trump has spent decades inflating the value of his wealth. He does it because he's insecure. He does it because it keeps him in the news, and he does it because it helps him get loans. He sued me for 3 pages of a biography I wrote about him, in which he said I essentially defamed him because I said he was worth about 30 times less than he said he was worth. And during the course of that litigation, we got evidence from his banks, including Deutsche Bank. And at a time when Donald Trump was saying he was worth $6 billion, and my sources were saying he was worth $230 million, we secured an audit from Deutsche Bank in which their own examination of his finances said he was worth only $780 million. That was great for our case because Trump's own bankers knew that he was, at that time, wildly inflating the value of what he had.
This is what I don't understand, Tim, which is, I used to be head of the fraud section at the Department of Justice. And my question to a bank where there know your customer rules, money laundering regulations require financial institutions to know their customers and to know where they're getting their money and who they're dealing with. What does the chief compliance officer at that financial institution say in response to, if you knew that a customer was committing fraud, and the fraud, by the way, is directed at you, your institution.
Why would you approve doing business with that client?
Yeah, exactly.
Well, I think it happens all the time. Compliance officers at banks are notoriously feckless in a lot of cases.
Or they don't know, right?
Or they don't know. And they, they're lower on the totem pole in an organization. They don't really have the authority to kill a deal someone higher up than them wants to pursue. In the Deutsche Bank case, they went ahead and did a deal with Donald Trump, even though he had tried to stiff them on loans they had made to him on a Chicago project. The commercial side of the bank wouldn't do business with him. They had permanently barred him as a client. And Rosemary Vrablic, who testified in the state attorney general's case here in New York, was with the private bank. And she decided to go ahead and do business with him without getting inside her head, because I can't speak for what her own thoughts are. But I think she just liked the idea of doing business with the Trumps because that led her to the Kushners. She was introduced to Donald by Jared Kushner. So there's all of these just personal relationships that the average Joe and Jane don't have access to when they walk up to a bank teller. And people who are in the news or who are celebrities get access to this kind of stuff that others don't get. And I think the standards drop. So I guess it doesn't feel mysterious to me that they did business with him, even if it's reprehensible, which I think in some cases professionally it was, and certainly injudicious given his track record. He's a serial bankruptcy artist, and he routinely stiffed banks. I think the issue here is, was he a criminal in doing that? And, as a reporter, I didn't have the subpoena power to go down that route. I think we kind of stripped the bark off of him like an old tree in court. But, all we had to prove was I didn't act with malicious intent, that I went about my job and I tried to get as much information as I could. And I was fortunately confronted with a guy who was a bloviator and an exaggerator. And then in our deposition, we proved that he had lied more than, I think, 24 times on valuing different assets that he had said were worth more than they were. It's exactly what's in the attorney general's case right now, the state attorney general's case. But I think they have a high bar if they're going to prove he's a criminal. The idea of relying on Donald Trump's statements of financial condition, which Tish James' office is, as demonstrations of an attempt to defraud is tricky because he gave those things to the press as kind of marquee statements of how rich he was. And they were cartoons, basically. They were like cartoon books, highlights for children. His own accountants wouldn't sign off on those documents. Having said that, I think under New York law, they don't need to prove that the banks were harmed. That actually isn't a standard in this case. I think Trump has latched onto that because he has a reptilian sensibility about what plays in the popular imagination. And he can say, I'm being prosecuted, but no one was hurt. Why is this happening to me? When the real issue is you've been doing great inflation for your entire career, buddy, and someone is holding you to account for it. And under New York law, that in and itself is enough to prosecute you.
In their main case, that's the state's main case, they did have an expert witness who testified about the harm. Even though you don't have to prove it, it goes to the amount of damages because the state is seeking essentially disgorgement, which is the amount that Donald Trump unjustly received. And the theory is that he either wouldn't have gotten the loan or that the rate that was charged would be different because, it's kind of common sense, which is like if you and I go to a bank, I don't say you, but if I go to a bank, they're certainly going to look at my risk profile, and the riskier I am, they may decide not to loan me the money at all or to loan at a higher rate to account for the risk factors. So they had an expert talk about that and sort of assess what it would be. And obviously, that's why part of the battle here is not just on liability, but on what would the damages be if the rate would have been different. And that's where the defense case, which is to say, we were just happy to do business, is important because even if it doesn't defeat liability, it could go to damages. I have to say, I think one thing, and I don't know how much the state made of this, having somebody from the private wealth group testifying, they have their own interests. And I didn't assess her credibility on the stand. I didn't see her testify. But I would be very interested in, private wealth management, as happens a lot of times in large institutions. Different parts of a bank can have very different interests that don't necessarily align with what the bank overall wants to see. So a bank, for instance, a well-run bank could be very concerned about what's happening at the sales level. Are people saying and doing things that would help them get commissions, but that the bank overall does not want to see people doing? And so I did have a sense that, at least I was curious as to whether that was going on with respect to private wealth management, where they would be like, hey, we were kind of cheerleading this because this was going to be good for us, even if it wasn't necessarily what the bank overall would want to do.
Well, in fact, that's very true about Deutsche Bank. I think the private wealth group was cheerleading to get business at all costs from Donald Trump, even though another major part of the bank said he's not somebody we'll do business with again ever, and then gave the business to him on very favorable terms. But now oral arguments have ended. Testimony has ended. The judge in the case is going to rule sometime next month. And I think the issue here is, what does he do with all this information? He's already pulled the business licenses on Trump and some of the related operating entities. He can, I think, impose bigger damages potentially than 250, but I think that seems to be a cap, 250 million. How do you think about where this will land come January?
I just don't know. I mean, this is the one thing that we know for sure. There is liability on the first cause of action. So in some ways, it's already a bit of a game over. And it's really a question of what are the remedies for that first cause of action. Yes, there may or may not be liability and damages for the rest, but in some ways that may be icing. And I don't know how the judge will come out on those issues. I don't know how he will assess credibility. One thing that is, I think, kind of interesting is the judge is entitled to make fact-finding based on the credibility of the witnesses. Remember that Don Jr., Eric, Ivanka, and Donald Trump himself have all testified. The judge has already found Donald Trump not believable with respect to a gag order issue, where Trump said that he didn't intend to be referring to the judge's law clerk, and the judge said, I don't believe it. By the way, just because he said that doesn't mean he's going to find that he's incredible on everything. But he's entitled to make those fact findings, and that's very, very hard for any party to get reversed on appeal. So by testifying, those people, I won't say it's their one shot, but it is very much putting your hands in the fate of the fact finder. So it'll be interesting to see what Judge Engoron says about the believability of those witnesses in general.
Andrew, let's take another break and we'll come right back. I'm back with Andrew Weissmann, and we're discussing the New York Attorney General's prosecution of Donald Trump. Andrew, I wanted to ask you about, I guess, extra legal issues of all of this, because Trump is an unusual defendant. And you experienced this during the Mueller probe, where you have an active, serious investigation going on, and he's openly speaking about people you're investigating, like Paul Manafort, and he's tweeting about whether or not Paul Manafort is going to sort of display omerta and not testify against him. He's going to the press. He's talking about all aspects of the case without any kind of worry about that having consequences. And that has all come into play again in this case in New York. You know, you mentioned in the earlier segment that the judge in the case had to put a gag order on him because he was so out of bounds, and he promptly violated the terms of the gag order. That's also happened in one of the federal cases, the January 6th case, I believe. We talked in the top of the show of this long and illustrious parade of people and entities that you've prosecuted, from John Gotti to Enron. Where does Donald Trump fit in that spectrum for you when you watch him as a defendant, and how his political theater affects the rule of law?
So it's worth noting a couple of things. One, there is a recent decision on the gag order from the D.C. Circuit, that is the Court of Appeals in Washington, D.C. It's the decision that, in large part, affirms Judge Chutkan's gag order, where the circuit court said that some of the statements made by Donald Trump, the former president of the United States, the former leader of the free world, posed a significant and imminent danger with respect to the integrity of the judicial process. That is a stunning, just a stunning statement to be said about any elected official, let alone the leader of the free world. So that's
and the nation's top
finding.
Law enforcement official.
Yes. It is worth just going back to that, even though we're so inured to the fact that Donald Trump does that. In fact, he embraces it. And prosecutors, I think, are aware of that, whether it's a public corruption case or an organized crime case. Frankly, any sort of gang or group case where there is a hierarchy where power and money are involved. If you're a prosecutor, you worry about undue influence on witnesses.
From the top of the food chain.
Yep.
But as you've noted, Trump is an unusually powerful defendant.
Well, of course.
With unusual impacts. What's happening to the rule of law in this country right now when you have someone who's a defendant in multiple cases that are buttressed by substantive charges with long trails of evidence behind them, including recordings of his own voice in the Georgia case, asking people to commit voting fraud for him, or cameras at his own estate in Mar-a-Lago showing his own employees trying to hide classified documents from federal investigators. And yet he keeps pushing forward in the political theater, in the public theater. What is the ultimate impact of that on the judicial process and the rule of law?
Well, I think there's sort of a small picture and big picture. The small picture is I think that the courts, by and large, have done an incredible job at upholding the rule of law. I do think that the slowness of the judicial process takes its toll in terms of being able to have a trial of the former president before the election so that the public has the benefit of that information and the conclusion. But I think that in spite of all of the attacks, I think that the judges are, in general, doing a really good job in the same way that the courts did a really good job in response to over 60 challenges to the results of the election, where all of the ones that went to the merits were denied. So I think that the courts are going to be under considerable attack in the same way that prosecutors and the media are attacked by Donald Trump, because that's what he does when there's any sort of institution or people within those institutions who are standing up to an authoritarian personality. I think that the larger picture, though, is whether the public's going to give a damn, whether there are enough people who view that as a fundamental problem. And I think that was the thing that I found very upsetting about his being elected the first time. And this has nothing to do with policy choices. It's not about whether someone agrees or disagrees with his view on immigration or who should be judges, all sorts of policy implications. It's that I was just so surprised that people could overlook what I viewed as blatant racism, xenophobia, sexism, the denigration of the rule of law, that those were so fundamental that I didn't understand that those weren't deal breakers for a much larger group of the American public. You know, I'm in the middle of reading Liz Cheney's book, and as I think many people have said, you know, Liz Cheney and I politically are probably pretty much polar opposites, but this is one where there's a fundamental similarity in terms of how those differences are decided and played out, and the discussions you can have on a policy level within the framework of a democratic system and a republic that we have. And so what's sad is that that baseline is so important.
And because both of you believe that institutions and the rule of law and the processes that surround them matter, even if you disagree philosophically and politically, that the bedrock of civic engagement in communities are a respect for those things. And I think that that is the tissue that Donald Trump is trying to shred, along with the Constitution and democracy.
So, you know, the title of my book, Where Law Ends, comes from a John Locke quote, English philosopher, who said, "Where law ends, tyranny begins." And that quote is on the Justice Department walls on the outside on the limestone over the Department of Justice in Washington, D.C., because it's so fundamental to what the Department of Justice is. And as Loretta Lynch, the former Attorney General of the United States, has said, is that the Department of Justice, unlike any other department we have in cabinet level official, is founded on an idea, which is the rule of law. And to me, that sentiment of where law ends, tyranny begins is just so fundamentally appropriate to this time that we are in.
Andrew, I always like to ask guests at the end of the show what they've learned. And I wanted to ask you, sort of starting with the Mueller probe and up into the president, what have you learned about the impact of Donald Trump as a president and a former president, being a defendant, and in the process of being a defendant, again, undermining some fundamental thoughts and respect we have for the legal process?
So when I was a very young man, and I think I had not yet gone to law school, and I had been an intern at the ACLU, Roger Baldwin, who helped found the ACLU, was still alive. And he used to say that regardless of what is in the Constitution or in congressional statutes, that what's fundamentally important is that those values and precepts are in the hearts and minds of citizens of the United States. And I remember at the time thinking, what's he talking about? Like, if it's in the Constitution, we're done. If Congress has passed a law, we're done. It didn't resonate with me. And I think what I have learned is things that I thought were deeply rooted in the United States and that I took as a given and for granted. It's like the roots of a willow tree that are very shallow, and a strong wind can cause it to topple. And that what Roger Baldwin was saying is so true, that the fight and what it means to be, or what I think it means to be American, is something that has to be fought for and upheld and taught in every generation.
Yeah, to stay with your analogy of trees, when you were talking about willow trees, I was thinking the happy opposite of that are aspens, which are all connected at the roots and draw great strength from that fact. And as we go into this political year, I think we have to think like aspens and not like willows.
I love it.
We're also out of time. I could have talked to you for another day or two, and I'm glad you came on. Thanks for coming on today, Andrew.
Oh, thank you so much for inviting me. This was really, really great.
Andrew Weissmann is a professor at the NYU Law School and a veteran prosecutor. You can find him on Twitter at @aweissman_. Here at Crash Course, we believe that collisions can be messy, impressive, challenging, surprising, and always instructive. In today's Crash Course, I was reminded that no matter how much I go into the weeds on a topic, particularly the prosecution of Donald Trump, some of the larger truths always have to be recognized, specifically that Donald Trump remains a threat to the rule of law and a threat to democracy. What did you learn? We'd love to hear from you. You can tweet at the Bloomberg Opinion handle @opinion or me @TimO'Brien using the hashtag Bloomberg Crash Course. You can also subscribe to our show wherever you're listening right now and leave us a review. It helps more people find the show. This episode was produced by the indispensable and ever law-abiding Anna Mazarakis and me. Our supervising producer is Magnus Henriksen, and we had editing help from Sage Bauman, Jeff Grocott, Mike Nitza, and Christine Vanden Beilart. Blake Maples does our sound engineering, and our original theme song was composed by Luis Guerra. I'm Tim O'Brien. We'll be back next week with another Crash Course.